Hello, good morning. We're sitting here today with Miguel Poiarés Maduro, who's a professor of the School of Transnational Governance at the European University Institute in Florence. He's been Minister Deputy in the Portuguese government and also a very important position for this interview. He's been Advocate General of the European Court of Justice between 2003 and 2009. He's also a council member of European Council on Foreign Relations for Portugal. Hello, Miguel. How are you?
Hello, Nacha. Nice to see you.
Well, I mean, thanks for talking to us. This last week has been quite troubling or quite intense in terms of the ruling which came out of the German Constitutional Court. Because you know these matters very well. You know you've been very active on this field. We wanted to talk to you. To have a first impression. Financial Times today says that this ruling is sort of a declaration of war of the German Constitutional Court on the European Court of Justice and the European legal system. So I know this is very technical, but we talked about this before. You're a very good communicator. You explain things very well. So we wanted to talk to you to a kind of a wider audience. Let's try to focus the theme a bit on this. Why is this ruling so important? Why did it come in a moment which captured all the attention? How much should we worry about this? Is this warlike language appropriate or not, Miguel?
So to continue to employ the metaphor that the Financial Times uses, we could say that until this decision, the German Constitutional Court and the European Court of Justice were in a kind of nuclear deterrence mode. The European Court of Justice had always clearly affirmed the supremacy and the primacy of EU law over national law, including over national constitutional rules, and that it was for the European Court of Justice to have the ultimate authority on the definition of the scope of competences of the European Union and the validity of the acts of the European Union, including the ECB. But the German Constitutional Court had always reserved itself the possibility to declare that a particular EU act might be ultra vires, that is, that the particular EU act might be beyond the competences that in its view the German state would have transferred to the European Union, but had never acted on this. And this kind of mutual deterrence mode had worked reasonably well because the European Court of Justice had always paid attention to the concerns of national constitutional courts, not only the German Constitutional Court, and the developments of EU law had always incorporated to some extent those concerns, but was able to do that while securing the uniform application of EU law, because the risk when a national constitutional court will start assessing the validity and determining that a particular EU act is not applicable in that state is that the uniform application of EU law is put into question, and therefore equality under the law and the rule of law in the European Union legal order and the European Union is challenged. What happens with this decision is, for the first time, the German Constitutional Court actually launches the bomb and triggers the nuclear device and says, in this case, we believe that the European Court of Justice itself has went ultra vires because it has accepted an ultra vires decision of the European Central Bank, because this decision, in their view, does not fit the scope of competences of the European Union, in this case of the European Central Bank, and as a consequence, because they do not have direct jurisdiction on the European Central Bank, what they do is to order the German institutions, in particular the Bundesbank and the government, to do everything they can to stop the application and the effects of the ECB decision, or not to adopt any act implementing the decisions of the ECB and the policy of the ECB in that matter. But at the same time, and this is why I would say they launch a device that is, to continue the war metaphor, they launch a device that is armed but the device has not exploded yet, because they give it 3 months for the German authorities and the Bundesbank in particular to obtain a justification on the proportionality of the measure by the ECB. And if the Bundesbank, as I believe it might be the case and may be the solution to save everybody's face, is able to obtain informations that allow the Bundesbank to say that they are convinced and satisfied with the proportionality of the measure, the Bundesbank may then say that that they have obtained what was required by for them by the German Constitutional Court, and in that context they might continue to implement the decisions of the ECB, and the weapon may never explode because Germany may never get into an actual infringement of EU law. But at this moment, the decision is the biggest threat, on the one hand, to the policy of the ECB, and on the other hand, to the authority and uniform application of EU law.
So we are in a very kind of a Hitchcock situation in which there is this bomb under the table
Yes.
with the clock going on for these 3 months. And all this saga has to do with something which is closely related to the crisis that we're living through today, but also with the crisis that we experienced since 2008. It is not on a marginal matter which lawmakers would find maybe abstract or even had nothing to do with citizens, but on a core issue, which is when the European Central Bank decided to do whatever it took to save the euro, and it went on a very expansive program of purchases of debt as to break the loop between sovereign debt and in the crisis of the eurozone. So this public sector purchase program is the main thing. There are people saying that in fact it's true that the ECB has gone beyond its mandate throughout this crisis for good reasons to save the euro, but its mandate is just to keep inflation at 2%, and that therefore there is a basis for saying that we're doing fiscal policy kind of through the back door with adequate instruments because we don't have the right instruments to do this. Is there at least on that an amount of reason that you could concede to the German Constitutional Court in terms of something which Germans very generally worry a lot about, and they're worrying also about throughout this crisis, that we are doing a kind of a covert financing of member states' debt and that the ECB is exceeding its role?
Yeah. So a preliminary point still also in part on the previous aspect. Even if the weapon has not exploded, it's important. I don't want to undervalue what's taking place. The simple threat that exists, and even more than what the German Constitutional Court says regarding the past policy of the ECB, what is said regarding the new policy of the ECB, because even the previous policy, the German Constitutional Court was faced with two arguments. The first one was, is the policy of the ECB of buying public debt in the market a violation of Article 123, the prohibition of monetary financing? And then the second aspect was the proportionality. And in the first one, the German Constitutional Court actually agreed with the European Court of Justice, said that it was not a violation of 123, but it said that it was not a violation of 123 because of reasons that no longer apply to the new program, the temporary program that the ECB has announced in the context of the pandemic. They said it was not a violation of the prohibition of monetary financing because the previous policy was subject to certain conditions, such as, for example, limits on the debt that the ECB will buy, not more than 33%, such as the distribution of how such debt will be bought. Nothing of this no longer applies to the new policy. So even if the weapon, again, has not exploded, this strongly conditions the position Germany will take, on the one hand, including on the current negotiations on the financial rescue package. But then second, it clearly strongly brings uncertainty into the effectiveness and the political backing of the decision of the ECB. And that's the problem. At the moment, more than the actual legal conflict, because as I said, during these 3 months, maybe a solution is found and we will not have that, is the uncertainty that the shadow that this casts on the current policy of the ECB and how the markets will address that. Now, on the specific, whether or not there are arguments that can support the position of the German Constitutional Court. There are certainly arguments and sound legal arguments to say that the ECB went beyond its mandate and went beyond what is in the treaties. But there are also arguments on the other direction. And the first point that I believe important to make is this. In the European Union legal order, it is for the European Court of Justice to balance those arguments and take the final decision. Like in any other legal order, we have a final jurisdiction that is the one that has the authority to define whether the acts of the institutions within those jurisdictions are lawful or not. Sometimes we agree with those judicial decisions, other times we do not, but it is for that institution to take it. It's not for the German Constitutional Court. But on the arguments itself, I think it is possible to say, on the one hand, that the decision is monetary based, and that even the German Constitutional Court recognizes that. The German Constitutional Court recognizes that the decision pursues a monetary goal, okay? But then says that the decision also has economic effects, and those economic effects are not within the mandate of the ECB. But it also recognizes, as the European Court of Justice did, that it is impossible for the ECB to take a decision that is only monetary based. Any monetary decision has economic effects. What the German Constitutional Court seems to say is that if the decision has economic effects, then the European Central Bank ought to have to take into account those economic effects and lists the potential negative economic effects that, in its view, the ECB is not taking into account, such as, for example, the negative impact on savings, the possible likelihood of creating real estate bubbles, all aspects, by the way, that are cause of concern regarding the ECB policy in Germany. What is paradoxical, and I think it's wrong on the part of the German Constitutional Court, is that if the German Constitutional Court believes that even if the decision is guided to the pursuit of a monetary objective, the inflation target, but then also has economic effects and they ought to be taken into account, then both the negative, but then also the positive economic effects ought to be taken into account. And we don't see that in the German Constitutional Court. If the German Constitutional Court believes that the ECB ought to take into account also the economic effects, then it ought to be both the negative and the positive, and that is missing from the decision. And when you get into that kind of balancing, this is a usual question for courts. Every court has to ask itself, is the court the more apt institution to make that balance? And is the German court the more apt institution to make that balance? Because German court, by reason of who participates in that decision, will only have, and that's why you see only certain economic effects portrayed in the decision of the German court, only takes into account certain economic effects that the parties in Germany bring to it. They can't take into account the positive economic effects that may be taking place in other countries and that the ECB will have to take into account. So if anything, I believe that the German Constitutional Court decision highlights the importance for such a balance to be made at the European Union level, and then for the European Court of Justice to do it, and moreover, in light of the economic nature of the arguments, for a high level of deference to be left to the European Central Bank, what the German Constitutional Court didn't do. Just final point on that. It would also be possible to say that though that doesn't seem to be the approach of the German Constitutional Court, that what we'll have to look is at the center of gravity of the measure. That looking at the economic effects would also serve to determine whether the measure was mostly an economic measure or mostly a monetary measure. But even that is a very hard reasoning to do and a very hard assessment to do when you have a measure that naturally necessarily is both pursuing monetary objectives and having economic effects. And moreover, the monetary objective, in my view, that the ECB can pursue is not only the inflation target. You could say that if you have a fragmentation of the financial markets and of the debts, the survival of the euro area itself is in question. And that's certainly a reason for the intervention of the ECB.
So what you have here in practice is a full review done by a constitutional court in Germany, of existing EU policy and two institutions which are independent, which are the ECB, which is an independent institution, and of course the European Court of Justice. So you have one independent institution doing a full review of another two independent institutions, and this is kind of what is shaking the legal buildings of the community, because people tend to think that the European Court of Justice works like the Council or the Commission or like the ECB in that you have governors or you have the 27 constitutional courts represented. But this is not the case. We don't have the 27 constitutional courts represented in an institution which then makes constitutional law for the European Union. And in a sense, what you suggest in your piece is when you discuss constitutional pluralism is that we have to be careful not to bring the 27 constitutional courts into the process, because then that will destroy probably the EU, right?
Exactly. We have an institution that is the European Court of Justice where you have the 27 legal traditions and legal systems indirectly represented, because you have judges from all those nationalities and coming from all those legal systems. But that's very hard. That's very different from giving each national constitutional court or its national Supreme Court in countries that don't have a constitutional court the right to decide on its own on the validity of EU Act, because by definition that court is going to look at the relationship of EU law with its legal order, and will tend to ignore the need for an EU Act to take into account what are its effects and what is the realities and what are the needs of the constitutional orders of all the member states. And actually, in that respect, this German Constitutional Court decision is a good example of that, as I said. If you need, you see what is the problem with that, because the approach of the German Constitutional Court is, to a certain extent, a parochial. It looks at EU law from the lenses of of Germany only, and does not take into account that EU law, and in this case the ECB, has to define policy not for one state, but in light of the interests of 27 states. And that's the real risk that you will have if each national court will do it. And that's the concern that this decision raises, that it may create a precedent that will tempt other national constitutional courts to replicate the same approach. We have had already the president of the Polish Constitutional Court saying that they agree with the German Constitutional Court and that they feel entitled to do the same and in other areas. And we therefore might see decisions challenging in the same way EU law coming from Poland or coming from Hungary, and that may be related with rule of law questions in those countries. And this highlights the danger in this decision. On the other hand, I also think that there's a real risk in this, but it may turn out differently than what we fear at the moment. And it might end up actually undermining more the credibility of the German Constitutional Court and the European Court of Justice. Why? Because I believe that this decision, it was the wrong decision, in my view, for the German Constitutional Court to challenge the European Court of Justice. And it might lead other national constitutional courts to instead rally behind the European Court of Justice. And you can certainly have other courts, but I think will be a minority, supporting and following the German Constitutional Court. But if the courts that will do that will be the courts in Hungary and in Poland, and moreover, if following that, the European Court of Justice will apply financial penalties to those states, as it can under EU law, for not complying with EU law decisions, those states that are particularly dependent from EU funds and EU money might have no alternative in the end than complying with EU law. And if the other national constitutional and Supreme Courts instead will rally behind the European Court of Justice, you might come out at the end of this with the authority of the European Court and of EU law reinforced instead of undermining. I don't exclude that as a possible outcome, and I actually think that will be the more positive outcome.
Yeah. And looking a bit into the future, there is, especially you coming from Portugal, where we have seen quite an intense exchange of views, to put it mildly, coming from Portugal on some positions adopted by the Dutch government on the recovery program, how to get out of the crisis, this very famous Corona bonds or Euro bonds discussion. The very limited, not limited in quantity, because the pandemic emergency purchase program adopted by the ECB is been huge, but we thought that it was limited in terms of the legal challenge because we had a precedent and we thought that this was fully okay, and therefore there were no doubts about the validity of the already existing measures which the ECB was taking. But what we are discussing and what you are suggesting is that actually the German Constitutional Court is tying Angela Merkel to the mast in order to ensure that what comes now, which is not the emergency measures, but the full deployment of whatever you want to call it, either Marshall plans or Corona bonds or Euro bonds, these will be very severely limited by this ruling of the German Constitutional Court, right? So we're closing, or the German court is closing or limiting what the German government will do, and this will have political repercussions because countries such as your country, Spain, Italy, are at the moment very sensitive on these issues, but also the Dutch and the Germans are. So it's having a major political impact, right? And so how do we get out of this? Is it true that this will weigh a lot on the recovery program?
There is one aspect in which I think we need, in the countries of the southern of Europe and the countries that need more support from the European Union, need to recognize and acknowledge what the decision is saying in order actually to pursue what we believe is necessary. I was writing this weekend an op-ed in Portugal where I was saying that this is a good, this reminds us that in order for Europe to do what we believe is necessary, we need to acknowledge what is the position of the others too. And the same mistake that the German Constitutional Court is doing, it's also often done, for example, in Portugal. We believe that it's obvious that the Germans and the Dutch ought to accept to mutualize the debt and ought to accept to be solidarity, as we put it, and we don't acknowledge the sensitivity and the interests in those states that make that hard to happen. And in that respect, the German Constitutional Court is important because it highlights it's based on a link that it establishes, and that link is not new. The German Constitutional Court has been stating that in previous decisions, between a conception of democracy that in my view is wrong, but is the dominant conception of democracy in the German Constitutional Court and in German society, a conception of protecting German democracy and protecting German budgetary and fiscal autonomy. Basically, the German Constitutional Court says if Germany becomes too liable for this, through mutualization of debt, for example, for decisions with fiscal impact taken in other member states of the European Union, it's democracy, it's space for democratic deliberation, its freedom of democratic deliberation of its citizens is limited, is constrained. Because if you have to pay for decisions of others on which you have no democratic voice on the one hand, and that may limit your fiscal capacity, then it's your own democracy. And that's the basis for this decision. So it's not a limit on solidarity. In Europe, it's an idea that they're protecting German democracy. And we need to acknowledge that in order to understand the obstacles that we face. Now, this is bound, and this is one of the negative impacts of the decision, to limit German positions in the current negotiations, as I was saying. And I believe that it's not enough for us to simply say that that is wrong. So we have to find a solution for Europe to do what is necessary, that as much as possible tries to accommodate that German view and that understanding of the German Constitutional Court and their conception of democracy. And in my view, that's the silver line of this, in my view, the best possibility to do that, the best possibility for the European Union to develop the fiscal capacity that it needs, the financial power that it needs to provide the genuine, effective EU answer, without creating this fear of contingent liabilities in Germany that will limit somehow German democracy, is by adopting genuine own resources. Because the advantage of genuine own resources is that they don't become contingent liabilities. You don't become liable, contrary to mutualization of debt, to extents that you are not fully defined and that you don't know how they will materialize itself, if they may or not materialize itself. If you do this through genuine own resources, what each citizen in each member state of the European Union knows is that their obligations are limited to what they contribute to the EU budget through the European taxes that are defined. That's it. They have no other liability beyond that, and then it's for the EU budget to guarantee and to support other actions of the Union, including issuing of bonds, if necessary, for a recovery fund. So I think that if we are clever, we will read that decision as highlighting the extent to which we need to move the European Union and its fiscal capacity into a model that depends on genuine own resources.
Yeah, that's the fiscal union element that we've been missing from the monetary union, which requires a bit more political union, maybe a bit more legitimacy. But at the end, as you say, sometimes the German position reminds me of kind of a reversed British colonies and Britain argument, is that Germans are saying no taxation without representation. We don't want to send money to others without having consulted ourselves, you know.
It is that.
So, and one last question. The Commission is considering launching an infringement procedure against Germany. There is a bit of a bluff in this because it would make things considerably worse. Even if you're right, sometimes you don't want to be proven right because of the consequences. Do you think this is a bluff by the Commission, or they will ultimately have to go through this infringement procedure as to ensure that there is a level playing field when it comes to constitutional matters? And as you say, that Hungary and Poland do not decide to go also rush on their own on these issues?
I think it's the Commission has not formally opened an infringement procedure, but has threatened to open it. And I think this is the prudent and the right approach in light of the dilemma that the Commission faces, and that is reflected on what you just stated. Because on the one hand, the Commission doesn't want to inflate and increase the stakes and inflammate even more the conflict. But on the other hand, it cannot simply ignore it. Because if it will say we will not open an infringement procedure, whatever happens, because it's Germany, without saying that, what will be the authority of the Commission to do so once Poland will do this or once Hungary will do this? It will be very complicated. So what I think the Commission did is, and it's not uncommon for the Commission to not immediately open an infringement procedure, but to start informally by noticing that it might open it and asking additional information from the state. So this is not new, and in my view, it's the right approach in this case, because if I am right, then during these 3 months that we were talking about before, it may be possible for the Bundesbank to find a justification that allows the Bundesbank to say that they will get information from the ECB without the ECB answering directly to the demand of the German Constitutional Court. But of course, the ECB can answer to requests from information from national central banks. The Bundesbank, in the meanwhile, will say, we are satisfied that this complies with proportionality, and as such, then they will continue to implement the decisions of the ECB, and so no actual infringement will take place, and the Commission will not need to open a formal infringement procedure. So the Commission will have preserved its right and its authority to initiate such an infringement procedure regarding other member states, but at the same time without formally escalating the conflict with Germany. That's what I think it will happen. By the way, a lot of this will depend on what the German Bundesbank will do, because if the German Bundesbank, that as we know, has not been very friendly and very supportive of the policy of the ECB, will use this to empower itself and will actually challenge the policy of the ECB, then we might end up having a real serious problem in the European Union that will be hard to solve. I hope that some kind of accommodation will be done. What this accommodation will be due and the extent to which it might undermine the effectiveness of the policy of the ECB, that's something that we'll have to see. But there is an element, I'm sure that the Bundesbank will try to use the decision of its German Constitutional Court to empower itself and obtain some amendments on the policy of the ECB. I'm sure that the other central banks and the ECB will try to limit that. But I think it's crucial that a solution is found between the central banks in these 3 months in order to avoid this.
Well, I think this was a lesson in how strategic courts can be. I mean, I think my students of political system of the European Union would be quite happy to see, how important, these institutions are in terms of preemptively and strategically behaving, anticipating and reacting to each other,
Sometimes for good reasons, other times for bad reasons, but they are.
But at the end of the day, as I tell my students, all EU bureaucrats get paid for just one thing, squaring circles. And this is basically what you get paid for. And this is an excellent example of, the need to square this very complicated circle, so everybody can fit in, and no one is left out. I mean, thanks for making it so interesting in such a difficult for such a difficult topic. As you saw, even my dog came in to listen to you because he thought it was very interesting.
We won over the other topic.